Good evening, everyone. I'm Rakhi Gautam from greytHR. I welcome you all today to our Ask the Expert webinar Parichay. Today, we are going to decrypt the Digital Personal Data Protection Act 2023. Now, before I dive into the topic, let's do a little housekeeping on how the session goes. So the session is divided into two parts. The first part will be the discussion with our expert, which will then be followed by an audience Q&A. So I can say audience Q&A is where time is all yours, dear attendees. You can start putting across your questions and we will take them up towards the end. Also, the session is currently being recorded. So if you happen to miss out on anything, do not worry at all. We've got you covered. We will share the recording with you once it is done. And also, this recording will be available on our greytHR official YouTube channel. So you can always go there, watch it again, and take down your notes. So without any further delay, let's start the session. In an era of evolving digital landscapes and growing concerns over data privacy, this webinar is your key to understanding the Digital Personal Data Protection Act 2023. Our expert speaker, Ms. Mehak Khanna, partner at Khaitan and Khaitan, will take us through the provisions of the Digital Personal Data Protection Act, equipping you with essential knowledge to navigate this transformative legal landscape. We will learn about employee rights under DPDPA and the potential penalties for non-compliance, ensuring you're well prepared to protect data privacy and avoid any legal pitfalls. Also, moderating this special session today will be Ms. Bhuvna Anand, Associate Manager, Legal at greytHR. Now, before we start, let me quickly take you all through our speakers' profiles. Mehak is a seasoned corporate lawyer with an impressive 15-year track record in law firms and in-house legal roles. Her career spans advising both large established companies and fast-growing tech startups along with investors. She has led complex restructuring and M&A transactions, excelled in contract drafting and negotiations, delivered top-tier corporate advisory services, managed real estate, deals, and adeptly handled technology, IT, and data privacy contracts and compliance. She is a recipient of prestigious awards such as ET Prime Women Leadership Award 2021, Asian Legal Business India Rising Star 2021, Forbes Under 40 Top General Counsel 2020, and 40 Under 40 Rising Star Award by Legal Era 2020. I think we have the perfect person with us today to discuss on this topic. Once again, welcome, Mehak. We're very excited to have you today with us.
Thank you so much for an amazing introduction, Rakhi. And it's a pleasure to be here. And I'm looking forward to having a fruitful discussion with Bhuvna. So thanks a lot for having me.
Likewise. Now, let me take you all quickly through our moderator's profile. Ms. Bhuvna handles greytIP's in-house legal support, contract management, and payroll statutory updates. She's a certified information privacy professional, certified information privacy manager, fellow of information privacy, and also a registered data protection professional in Europe. I think we have been, fortunate to bag both of them for this webinar. All the, both the experts in their respective fields. So thank you, Bhuvna, again for joining us. Now, I would like to hand over the session to you to spearhead this conversation with our speaker, Mehak. Over to you.
Thank you, Rakhi, for the introduction. Welcome, Mehak. It is actually a great and our privilege to have you here. It's going to be a fruitful discussion. A lot of audience waiting to hear from you. So let's do keeping the time constraint. We will jump into the topic straight. Since data being the new oil and privacy being the new normal now throughout the world, and now the burning topic in India, the most awaited, the day in and day out. So I would request you to give a quick introduction about this Digital Personal Data Protection Act, which we all know as DPDPA. So would like to have a brief about this from you.
Yes, absolutely. And on a lighter note, why just the new oil? I think data is the oil bullion and everything else,
Yes.
Considering the day and age we are in. And this law is extremely important, DPDPA as we know of it. It is, an important development in the legal system, and it's somehow an acknowledgement in the entire country that privacy rights of individuals are extremely important and those need to be protected. And just to give a brief background of DPDPA, of course, this law has been in the works for a few years now. There have been at least 5, 6 drafts of this law since 2016. There has been a lot of back and forth with the industry stakeholders. And eventually there was a draft that, the government thought they could come out with, which would be palatable to the industry as well, which has seen the likes of foreign laws being GDPR and CCPA. And they thought it would be easier to digest for the industry. So they came up with this particular version. And this particular law, of course, talks about protecting the personal data of individuals. Personal data has been defined as any data which helps identify a particular individual. And there are protection thresholds given under the law for protecting personal data. There are usage permissions given as to the fact that personal data of an individual can be used only with his or her consent and for legitimate uses. There's of course a category of exemptions which are there, a little vague, but nevertheless there in the law. And there are then, of course, there's this detailed investigative procedure as well as penalties that have been prescribed. And the intent of the government is clear that they recognize the individual's privacy rights, and they will go all out to protect those. And of course, with time, once the Data Protection Board, which is going to be the main authority dealing with DPDPA disputes, is set up, we'll of course get a real-time knowledge of how these disputes are going to be dealt with by the authority and how strict they're going to be in imposing per offense.
Yeah, that's true. So now that we have the act in place, now we're looking out for the effective date to be announced from the time, and it is anticipated from day in and day out updates that within a month we expect the rules to roll out and to the obligations to commence. So what are the broad steps that an organization should look into to have the compliance to DPDPA in place to ensure that all the organizations are compliant to this law? What is that you suggest, or in your
Sure.
opinion?
So two parts to your sure. Yes, I think so. Two parts to your question. Firstly, that this particular law states that certain provisions are going to come in force on a certain date as the central government will notify. And the law also mentions that certain provisions will commence on a different date than the rest of the provisions of the law. But surprisingly, the first consultative discussion with the MOS, which is the Minister of State for IT, was held yesterday with the industry bodies and the lawyers. We were all there as representing our stakeholders. And the minister made a very interesting comment to say that the law is in force. It came on force the day it was notified in the official gazette. Of course, the data protect as an authority is going to be set up in the next 30 days. The government said they will come out with the rules in the next 30 days, but he was very clear that the law is in motion. And if the companies and the industry does not comply with the provisions, then as soon as the data protection board is set up, the board is going to start picking up instances of defaults and start acting on those. So it was interesting to know that the discussion was not about so much as all of us were anticipating about what is going to be the transition period. Is it going to run in 2 years? Are there going to be exemptions? But the approach from the government seemed clear to set the ground running. And so that's one. On your second point as to how organizations need to prepare, I personally feel that all organizations need to prepare themselves at three levels. One is, of course, at the business level, which is that, they need to do a data audit to see what all sources of data they have, whether it's in digitized form or not, and whatever is in hard copy form, have they converted it into digitized form or not? Because eventually, Data Protection Act is applicable to any data which is stored, in digitized form. So it is important for them to do this data audit. One is that. Secondly, after doing a data audit, it is important for them to see what all measures they have in place, be it in terms of internal policies, the internal grievance redressal managers and officers, be it in terms of their hierarchies, be it in terms of the internal trainings, and how basically they need to manage the internal stakeholders in dealing with the data is all going to be covered as part of this first bucket. I think moving on from the organizational measures would be the second part of the measures, which are going to be the technical measures, which is going to involve the technical safeguards, checking the softwares, the hardwares, seeing how the data is to be encrypted, anonymized, checking the API journeys, the API pulls, so on and so forth. The third level of bucket is going to be the documentation, which is going to be going back and re-looking and reworking through all of the user and the customer T's and C's, the employee contracts, the consents, the privacy notices, privacy policies, vendor contracts, data protection agreements, so on and so forth. And the fourth level of bucket for organizations to prepare for this law needs to be employee sensitization as to what all data the employees are collecting, storing, how are they storing it, who has access to it, do they have enough safeguards, how are they transferring the data, is the data going out of the country, is the data being stored here, how is the data being deleted, how is the data being updated, how is the consent being taken, and how are those records being maintained. So I think these four buckets would be extremely crucial for any organization to be able to get this law right. And yes, I think they have no choice but to get this law right.
It's like, other than the techie organizations, the technology-based organizations, which are already up prepared or halfway, but for all other organizations which holds data in digital form, a lot of groundwork is required. And I think your session will be an eye-opener to start with, considering all this. So here, going back to the same, as you said, the first stepwise, what are the actions required? Here, what are the key items that you look at as the employer and the employee rights when it comes to information that is a lot on the personal information when it comes to employees, because any organization deals with a lot of data, especially not only the employees' information, but also with regard to others. For example, the very much GreytHR as an organization itself deals with a lot of customers and the payroll process. A lot of employee information is exchanged and processed here. So from your perspective, what are what does the DPDPA Act says about the employer rights and the employee rights here? What are the rights they have, and what are the key areas that they have to focus?
Absolutely. So, Rakhi, very pertinent question, because as employees working for an organization, a lot of their data is going to be collected by the organization in the course of employment, and hence, it is important for them also to know their rights as data principals. So, of course, they have a right that their consent should be taken. They have the right to withdraw the consent as well. They have the right to get the data updated and upgraded. They also have the right to withdraw their consent, especially upon termination of their employment. So their rights are consistent with any data principals' rights which are there under the law. Practically, how should an organization look at protecting the employee rights? I think it's important that an organization should collect the data which is in direct nexus to the employment and which is for a legitimate purpose in respect of the employment. Second, they should give clear opt-out consent options to the employees that their data is going to be deleted, and they can withdraw the consent once the employment is terminated, or if they move out of the country, so on and so forth. Thirdly, I think it's important that employees should have access to be able to update and upgrade their data. And fourthly, it is important for the employer to process the data for the purposes of employment only, and for whatever purpose they have the right to do it under the Act. For example, the Act broadly gives the employer the right to use the data for safeguarding themselves from any loss or liability, for the purposes of corporate espionage, for maintenance of confidentiality, for maintenance of trade secrets, intellectual property, so on and so forth. And hence, it is important for the organization that in case of any of these instances that I just mentioned, if they are using the employee data, then they need to create proper evidence and record of it, because in case a dispute arises, there should be clear usage and the purpose defined.
The proper records as to why
Yes.
we process,
As to why
what
they used it, whether it was in the course of employment or not. For example, if they've used it for maintenance of trade secret, or whether they've used it, for for prevention of corporate espionage, and all of that. So they need to create strong records and set the reasons in writing so that it adds as a backup.
And generally, employers deal with the employees' data to process their payroll, their performance, to evaluate their functional activities there. And other than that, not other than looking at it as an employee rights, I think it would be appropriate to say, as an individual, as a data principal, the personal information, not only with the employer, but also anywhere, in any part of our life, day in and day out, we share our information with a lot of in a lot of transactions. So every individual, other than as an employee, should know what are their rights as a data principal here, how their information is processed, right?
Yes. I think so. We've dealt with employer and employee relationship. Moving on
Yes.
to other data principles, including all of us, if our data is being taken, whether, it's in the capacity as customers or as clients or maybe by banks. So it's important to understand what all rights data principals who are common, men and women, what all rights they possess. So first important right is that their consent needs to be clear and unambiguous. They need to understand what they're consenting for. And the organizations taking their personal data need to be very clear as to what purpose their data is going to be used for. And only then the consent is going to be valid consent. So that's one. The second is that the data principal, which is the user or the customer, also has the right to keep getting the data updated and upgraded from time to time. So that's the other right. The third right that the data principal has is to appoint a nominee or a legal heir. So that's the third right. The fourth right is to be able to withdraw the consent. So the data principal can withdraw the consent when it's not needed. These are, of course, the important rights. From an organization standpoint, they need to ensure, the data principal need to ensure that, if they're noticing that an organization is not applying and employing reasonable safeguards, or if their data is being misused, then of course they have the right to raise their concerns, issues, notices, and also approach the Data Protection Board, which is going to be the authority that the government is setting up to deal with disputes under DPDPA.
So here, that was quite enlightening here. So in that case, when we look at it, it's basically broadly, it says when you share or when you process digital information, which holds the personal information of any individual,
Yes.
You can identify, or it could be an identifiable information when any entity or any organization, any person is processing it. There are
Yes.
certain steps proposed by this act. These are the do's and don'ts, how they have to process it. Now, coming to that particular individual's personal information, where you pointed out rightly on the consent part, like
Yes.
only with the consent of the individuals, their personal information can be processed
Hmm.
and in the right form. So here it revolves around the big concept of consent management.
Yes.
So what is your take on that? Like, what is that you suggest? Like, what are the challenges that you foresee organizations will have when it comes to consent management operation?
I think the challenges are going to be on three, four fronts. Firstly, to be able to map the entire data that an organization is collecting. And for
Exactly.
that purposes, as I mentioned, detailed data audit from a technical security and legal standpoint is going to be required, because still the organization doesn't know
Yeah,
what all sources of data it has, it will never be able to, proceed with it and take consent from the relevant people. So
right.
first is to map all the data,
Okay.
what all data is there from what all sources, and that might be a challenge. The second challenge I feel is going to be in dealing with all the stakeholders, because data most of the times doesn't come directly from customers and stakeholders to companies. At times it comes through intermediaries, at times it comes through third parties, at times it comes through vendors. So it
Right.
would be important to map the entire trail of data to see through what all stakeholders is the data coming from, because the approach for taking the consent for data is going to be different when the company is directly dealing with the users and the data principals, and it is going to be different when the company is dealing with the customers and the users through the data processors, which have also been defined under the law. So wherever there are these third parties, individuals, intermediaries, entities, and vendors involved who are taking and using and processing the data on behalf of the company, there's going to be another layer added, and the data processor again is going to be subject to certain legal obligations, and the data fiduciary, which is the company who's appointed the vendor, would need to ensure that the vendor does the job well and the company is contractually protected in case the vendor screws up. And so most of the onus here is going to be on the vendor. So the second part, just to summarize, is going to be to see whether the company is collecting the data directly and hence whether it needs to take the consent directly, or if there's a data processor slash vendor involved. And the third set of challenge is going to be able to get the documentation right. I
Yeah.
think the fact that it should be a consent, it should be an unambiguous, clear worded consent, and it should spell out the purpose. However, there's no format for it. There can't be one, because it is going to depend on case to case, situation to situation, industry to industry. And it would be very important to get the terms of the consent right, because if a dispute arises, this particular consent language is going to prove very crucial at that point in time. So these are the upfront challenges. Of course, there are going to be a lot of technical and security related challenges as well. A lot of challenges on the, encryption side. A lot of challenges on the product routing side. A lot of challenges on data storage server side as well. So all of those technical challenges would also be there, because each organization would now need to get into the technical and the infrastructure side to see how prepared they are to be able to protect the data and to prevent, breaches, hacks, and leaks. So yeah.
To protect at one side and also manage the consent given at one side, like maintaining the consent logs, whether it is
Absolutely.
or withdrawal, everything has to be end to end to be taken care of.
Yes.
So from there, as you said, like all these involved responsibilities, now comes the question on what if not, if there is a non-compliance, the key aspect, like what it leads to under this law. The penalties, what does this DPDPA say about the penalties Like, is
The
it like
DPDPA has gone all out, and it mentions penalties in numbers that we as Indians are not used to seeing. And if these penalties are actually imposed by the authorities, it is going to be a big dent into the pockets of the industries, and the numbers are such that may actually affect the cash flow situation as well. So there are various categories of penalties depending upon the situation. The highest, running into 250 crores. And of course, certain penalties for certain offenses being in the range of 200 crore as well. Of course, one needs to see, but if a data fiduciary breaches on its obligation, which is a company whose job is to protect the data principal's personal data, and if they default, their penalty can be up to 250 crores. If there is an additional breach in respect of data pertaining to children, then the penalty can go up to 200 crores, and so on and so forth. If there's a breach in the obligation to give notice to either the data protection board or the data principal, and one doesn't give that notice, the penalty can be up to 200 crores. So if you look at the numbers, these are quite high. And considering the earlier law, which was the Information Technology Act, read with the relevant rules, that particular law provided with, of course, lesser penalties, running into single digit crores. So this is, of course, a new change for the business world as well. And of course, we'll have to see how many of these penalties actually get imposed. But from the looks of it and from the intent of the government, I think they're, of course, quite serious about this law.
how does this mechanism work? The DPDPA would be the authority to adjudicate all these. Like earlier, prior to this, we in between the Information Technology Act, we had the certain regulations where it said within the 6 hours of timeline we had to report the breaches. Now, coming to the DPDPA, when it kicks in and comes to effect, like already it is expected that it has to start from day one, and there is no the transition is very limited and a phase wise, as you said. That's what it's anticipated. How does this mechanism work? It is the board will be constituted and they would take it up one instance and the incident wise, and we anticipate. What is that in your opinion? What's your observation here?
So I think 2, 3 things here, Bhuvna. It's an interesting question. Of course, the landscape is developing, but what the government has done is they've deleted the provision under the ID Act, and they've done away with the rules that used to deal with sensitive and personal data. So all of that is gone. Now all we have is this law. Of course, the CRT guidelines that you're talking about, where data breaches need to be reported to CRT, all of that stays.
Okay.
But the particular provisions of the ID Act that dealt with the sensitive and personal data, all of those have been done away with. And now the government has come out with the law. It's been almost a month and a half. In yesterday's consultative meeting, the minister said that they'll set up the board in the next 30 days. And once this particular data protection board is set up, they also said that within the next 30 days, they'll come up with rules on how, certain issues which are mentioned under the act to be prescribed by the central government, how those will work, and how, the data protection board is going to deal with certain issues. So the government is also going to come up with rules. So once we have the rules, once we have the data protection board, it is going to be amply clear that, the government is all ready to proceed with the defaults and breaches. Of course, then as the breaches and the defaults keep coming in, the data protection board would take it. If there's going to be, any issue or problem with the order of the data protection board, one would have the right to appeal it to the appellate board as well. The good thing that the government has done in this law is that they've restricted or rather omitted the powers of civil court. So the civil courts are not going to be involved here. It is going to be just this particular authority that they're setting up. And of course, it's appellate authority that is going to deal with these issues. So yeah, pretty much a standalone mechanism. To my mind, I think it should function like, we have the electricity tribunals in our country or the competition tribunals, which, have their own law, and they function as standalone tribunals dealing with a particular niche subject. So that seems to be the intent of the government.
Let's look forward. And that was quite informative and insightful updates that we received from you. So now I move on to, I think there are a lot of questions waiting to.
Yes, a lot of
hear
questions.
I'll go one by one. Srinivas Chakravarti has here it. The question says, is there any certificate that we need to get and display on our reception with regard to DPDPA to show compliance? I mean, like his intent is to ask like how we have for the Shops and Establishment Act, like that, whether you need any compliance certificate for DPDPA. That's his query.
No, there's no compliance certificate or no approval which is needed. DPDPA compliance is going to be a very fluid compliance that needs to be done at all levels, because this is a sort of compliance that will keep evolving as organizations keep taking more and more personally identifiable information of individuals.
Srinivas, I guess that answers your question. And there's one more anonymous question, that how can we know that the data that our company is processing is covered by DPDPA?
So if the data is, personal data, it is in digitized form, or if it is in a hard copy form, but it has been converted into digitized form, and it is being stored in India, and it is not being used for any domestic purpose or for any statistical purpose, and that data is not in the public domain, chances are that you would be hit by the provisions of this law, and you would need to comply with this law. And of course, like I said, every company should look at doing the data audit, which should be the first step. That should involve lawyers, law firms, their internal security and privacy stakeholders, and of course, their technical experts as well.
Right. Then are there any exceptions allowed for employment-related data collection?
Yes, there are exceptions which are allowed, and in fact, I'd mentioned that as well. Not in terms of the exception, but the usage of the data by employers is allowed. Employers can use the data of data principles if it is for the purposes of employment, or for safeguarding the employer rights, or for preventing a loss or liability to the employer, or for prevention of espionage, or for maintenance of confidentiality, or maintenance of trade secrets, intellectual property, or if it is classified information, so on and so forth. So these are the purposes which are considered to be legitimate, and if the employer is using the data of the data principle, they can use it for these purposes.
Right. And do you expect the legitimate, the expression would also likely to expand later from the definitions?
I hope so. I mean, the legitimate uses or the reasonable safeguards, these are terms. Let's see if the rules can throw more light on these terms, because one would want, personally, one would want, but I doubt, because these are terms that are very unlikely to be defined in an exhaustive manner. Because, like I said, data is such a fluid topic, and the kind of data that every company would be taking from individuals, and the usage is going to differ. So it would be very difficult to make it an exhaustive definition and say this is just what we seem to be legitimate use and nothing else, or this is what is going to be the reasonable standard for using the data and nothing else. So I think I also understand the predicament of the lawmakers, because of the nature of the subject that they're dealing with.
It's all depends on the facts and the circumstances there.
Absolutely.
Okay. Moving on to the next question. What technical standards are to be implemented now?
Of course, once a detailed audit is done, that the and the company knows what are the sources of data, then they should look at least the bare minimum 4 or 5 standards that I can think of. Of course, you know, ISO standards aside, there are going to be certain technical measures. They should put certain controls in place. They should have, robust measures, should go back and check their firewalls, antiviruses, all of that, should configure and keep their software and hardware securely. They should, of course, use methods to anonymize and encrypt the data, and they should keep testing the efficacy of their technical processes on a regular basis and keep taking third-party certifications to see that their systems are compliant and there are no leaks and gaps.
So like something like the ISO 27001, 20002.
That is the bare minimum standard for sure.
Minimum controls
that should
and
be the
process
minimum.
information security standards to be
Yes.
maintained.
Yes.
And here is Ludimar for a long time. If the company is affiliated with an European company that has a higher level of data protection, is the company in India need to adapt a different policy?
No. So if you are, an affiliate or a group company of a multinational corporation based out of Europe, which is governed by GDPR, chances are that all the processes and thresholds and standards would already be in place. Even if those are stricter than the Indian ones, you're still protected. You can just adopt the same measures, of course, in the Indian context, and the documentation would need to be changed and revised to suit the Indian law.
Does the India DPDPA address sensitive personal data or international data transfers? I see two things here. Like the question is like, does the India DPDPA address sensitive personal data or international data transfers? I think let's keep it as two separate set of questions, and you can answer that.
Yes.
Coming to sensitive
the law, yes, the law does not define sensitive personal data and only defines what personal data is, which means any data of an individual, which is, identifiable. Basically, any data that helps you identify an individual is personal data. And sensitive personal data, unfortunately, is not defined under this law, but personal data would include anything sensitive or non-sensitive. So that's the first part of the question. I think in terms of the second part of the question, you want to know that if
whether DPDPA
the government, if and whether the government can restrict the transfer of data outside the country. So yes, the central government has kept the right under the law. By notification, they can come up with any regulation which can restrict the right of data of a person by the company to any country that they notify. So it should depend on reciprocity, on the level of relationships that the Indian government has with other countries. But yes, they've retained the right with themselves to come up with a list where they can restrict data transfers.
So as of now, there's no restriction.
As of now, they've not mentioned, but yes, we'll have to wait and watch. Probably in the upcoming rules, we might have something.
Right.
So yes.
Okay. Then the next question is on consent. It says like, what is consent under the DPDPA?
So the consent under the DPDPA means the consent to be able to use the data of the data principal. And that consent needs to be taken the moment this law has, comes into force. It has already come into force. So now is the time to be able to take the consent. Of course, this consent is going to be for the data which is taken in future or the data which was taken in the past. What date or time should the consent be taken? There's no specific date in terms of a transition period for the consent to be taken, which has been specified by the government or the minister. In fact, at yesterday's consultative meeting, there were a lot of questions that, we'd asked in terms of if there can be certain, timelines which can be extended, if there can be certain extended periods for the company to be able to take consent from the time, the board is set up or certain provisions are notified or the government makes the rules. But So far, the response of the government has been that in their eyes, the law has been notified, it's there, and the organization need to start complying with it, which means that if they've not already taken the consent, they should look at taking the consent at the earliest.
So it's like with immediate effect.
Absolutely.
So that says a message, correct me if I'm wrong, like you take a consent for a particular activity, to process for a particular activity. So you have to stick to that. If you are going to do one more activity, then you have to take another explicit consent.
Yes, that's correct. So the purpose for which the consent is to be taken, if that purpose is changing or there are various other purposes that keep getting added, then the consent would need to get amended as well.
So is there a
Yes.
scope to keep a very general, a broad form of consent for many things?
Though the law doesn't prescribe that, but Bhumna, I was just thinking that the general consent is normally part of every company's privacy policy and user terms and conditions as
Yes.
well. But if that would have been the idea, I don't think we would have needed to go into the depth, yes, of data protection and have this law in the first place. I think the government is looking at specific use based consents because they genuinely want the companies to be able to justify the purpose for which they are using the data, and they want the data principal to know what that purpose is. And that, I think, can only be met if the language of the consent is specific and not the generic one that we keep seeing in the privacy policy and the user terms and conditions. Also, the method of taking consent would need to change. I think in terms of whether the user is actually reading that language or not is going to be very crucial in order to determine that the consent was unambiguous, clear, and absolutely well explained to the user. So these are some things that would need to be taken care of by the companies and of course by the lawyers who would be drafting these consents as well.
So the letter and the spirit is very clear, that revolves around the consent.
Yes.
So here comes Vaibhav have a question. Many organizations do not provide the access to update the personal information to their employees, and only the HR team has that access. So does DPDPA makes it necessary for the organizations to give the access to its employees to update their own data? Or it is one of the steps the organization should take now to be on a positive side of the law?
The law says that every data principal whose personal data is with an organization should have the right to update and upgrade their data. So if the organization is not giving the right to each employee, a lot of times organizations allow that through HR portals. But if there's no such portal and there's no such way to upgrade the data, then there should be at least a process through the HR teams for the data principals being employees to be able to update their data and their information, because that is something which is part of the data principals' rights, and the organization would need to ensure that they put some process in place to be able to do that.
So the employees have the right to update and correct the data. If the HR is dealing with the employee information, the employee always has the right to go and correct it and update it from time to time in whichever form the organization wants to update it.
Yes. And the organization, upon receiving the request for correction, completion, or updation, would need to ensure that they correct the inaccurate data, they complete it, and they update it. So it's upon them as well to be able to show that they have some sort of a mechanism where people can update and correct their data. Yes.
Here is next to Vivek Rajendran. With respect to consent, do we need to take consent for existing subscribers? Since DPDP is already a law which is cut off as to when consent will apply with regard to consent of customer. More existing customer, the same question what we discussed earlier, like from the time the law is already in place, so the existing customer, whether the organization have the consent or not. So it has to go back to the customers and ensure they have the consent in place, whether it's a subscription or it's a customer whose data is processed.
Yes, so correct. I mean, if so, three things here, I think. If consent of the customer has not been taken, then it should be taken. Uh, the law, as we know, has been notified in the official gazette. As per the government, it's a valid law. Of course, the government did mention in the law that they will notify certain provisions that need to be notified on a later date. But their stance, including in the meeting yesterday, has been very clear that the provisions which are there in the law need to be complied with, and the consent provision, which is Section 5, that talks about consent notice being sent to users, customers, or any other data principals, should be done. And that's what would need to be done, I think, at the earliest, as maybe reasonably practicable, of course. But that's where we stand right now.
So it's like we have to go back, as you said, we have to go back and check whether we have the consents in place. If not, the consents should be taken at the
Yes.
earliest.
Yes.
So that would answer Vivek's question here. Again, Vivek has one more question. Also, basis earlier consent for existing subscribers covers generic language. So for new products, do we need to take consent prior sharing marketing messages, mails, voice calls?
Yes. So if there is a generic consent, but the generic consent does not mention specific usage or does not mention usage at all, then for the company to be able to show that the consent is clear and the consent is for a legitimate purpose, they would need to change the wording of the consent. Also, if the consent is being taken for one purpose, but later on other teams and departments start using the data for other purposes for which the consent was not taken, whether those teams are sales, marketing, products, so on and so forth, it would be important to update and amend the consent language and take the consent again from the users to be able to create a correct and detailed track of the fact that the user has given the consent for the right reason.
Here is another broad question. How does DPDP Act impact data handling and processing practices?
I think it impacts in a 360-degree manner, because there is nothing that is going to be the same in terms of organizational measures, business measures, technical measures, or documentational or legal measures. I think the way the company deals with personal data, the way it stores, saves, processes the personal data, the way it asks its vendors to deal with customers and users' personal data, and the way its own teams think about products and processes where they need customer data, all this is definitely going to change.
So it's all like nowadays there is no organization which is dealing only with physical copies, or everything is digitized. We all deal with digital data day in and day out. So as you rightly said, it's a 360-degree measure that you have to look around and watch your steps and go with the compliance one by one effectively from now onwards. So next is the Harshavardhan's question here. For multinational organizations where data of employees and vendors are usually shared with counterparts of other countries, how can the Indian organization sharing this information protect itself from the rules and regulations prescribed in DPDPA?
Very pertinent question. So wherever there are these type of contracts within the group companies or outside, outside with third parties, it is important to have proper documentation. And hence the intercompany data transfer agreements or the data protection agreements, within the company, or for that matter, the third party data processing contracts with vendors, all of those would need to be reworked, rechecked, and be reworded if required to see that they comply with this law. And so that is something that would need to be done. And in addition to all of that, certain policies would need to be laid out. There would be certain terms and conditions that would need to be revised. So yes, it would be important to have documentation in place to be able to deal with such, arrangements.
Right. I see a lot of questions coming in. I just would like to tell the audience, like, since we have 10 minutes left, we will try to cover as many as questions possible. In case if we leave any question unanswered, you can always feel free to write to us in the Great Tribe community and we will get it answered by the subject matter expert. So we will just quickly go through the questions. Do we have the do's and don'ts specified by for employer and employee?
Do's and don'ts for employers and employees. There are no do's and don'ts as such, but the crux of the law is clear that of course, the employer can use the employee's personal data for the purposes of employment, for the purposes of protecting the trade secrets, for the purposes of preventing and preventing a corporate espionage and so on and so forth. So those are the rights that the employer has. However, there's also a responsibility to protect the data and give the rights to the employee that are available to any data principal, which is, one, and to be able to correct and update the data. Secondly, to be able to opt out of the consent, especially once the employment gets terminated, so on and so forth.
Right. This annexing to that, there is Sangeet Malhotra's questions. Can we keep data of employee after he or she has left or resigned? Because in case of salary data, we need to keep it for record purpose, which we have been doing over years. Something connected with the data retention under the statutory obligations where some information has to be retained. So what's your take on this? Because DPDPA doesn't stop any other act where the provision says that you have to retain certain information.
So DPDPA does not mention a retention period up to which the data is to be retained. Of course, if the government comes up with certain rules, we might have a timeline in future, not as of now. However, DPDPA does mention that if some other law requires the data to be saved or stored or retained for a certain period, then that period is complied with. For example, the tax laws prescribe a certain period for the data to be saved for. RBI guidelines, wherever applicable to institutions and companies, also prescribe for a certain period where the data needs to be stored and so on and so forth. So if there is a specific law that provides for a data retention period, that of course would need to be complied with.
In aligning with the DPDPA compliance.
Yes. So as of now, DPDPA does not have a retention period. So all the laws and their periods would apply as it is.
Yes, it is.
Yes.
Hiral has a question. Will there be any training provided for this law? No, Hiral, that's no training as such, but you can feel free to write to us in the community.
Yes, absolutely. You can write to us and we can, help you with the compliance and also provide training.
Yes. Nisha Patel have a question. Do we have to mention it in our current policy? I'm presuming that in the privacy policy or in their organizational policy document, that what kind of complaints, like it is a part of awareness also that how the employees.
Yes, absolutely. All the policies, all the documentation, the people would need to be checked and reworked.
Yes.
So, whether it's the vendor side policies, whether it's the employee policies, whether it's the user or customer side of policies and documents, everything would need to be checked and reworked.
Everything requires an end-to-end revisit, check, and change whatever modifications are required. So there's one more question. What kind of an impact an organization might get if they are working in an outsourcing model?
If organizations are working on an outsourcing model and they're outsourcing a lot of their work, especially the work on the technical and IT side to third-party vendors, then they're going to be data fiduciaries, and those third-party vendors who are working on their instructions and collecting this user personal data on their instructions, those vendors are going to be data processors. And these companies would need to be extremely careful that they ensure that these data processors are processing and managing the data in compliance with Indian laws, and the contract between the company and its vendors would need to be made extremely, extremely watertight. And for an outsourcing industry, considering their entire business depends on having these third-party vendors, it would be extremely important to revisit and reword all of their vendor contracts and the data processor contracts, as well as insert proper indemnity and liability clauses, as well as other additional safeguards. And we are currently doing that for a lot of our outsourcing company clients, and that's the nature of their business, that they'll have to now revisit all of their contracts, but that's how it is.
Yeah. Nisha has connected her policy question, like where she says, like as we discussed, it's the same. I mean, clearly specify like what we did for GDPR. So all the policy documents processes has to be revisited and updated as per to comply with the DPDPA.
Absolutely. All of the policies, all of the code of ethics vis-a-vis the vendors, third parties, employees, users would need to be revisited. There would be privacy consent notices that would need to be drafted. All the contracts would need to be revisited. So yes, it's going to be a 360 change in the documentation.
One question now with this, we wrap it up, and the others we will ask in the community. Apurva Deda, are there any exceptions of the applicability of law on startups?
For startups, there are no exemptions. The law does mention that the central government, if it wants, may come up with exemptions in the future. And a lot of startups were there yesterday with a meeting with the MOS. They did speak about their cost of compliance. They did ask if there are going to be any exemptions. The government was clear to say there are going to be no, blanket exceptions and exemptions given. And the government said if at all they come up with exemptions, it is going to be for extremely limited categories of companies, as in when they come up with those. And third thing, which the minister mentions, which was very interesting, he said that considering most of the companies in India are used to either the group companies or the vendors being governed by GDPR and certain other stringent foreign laws. So for them, it should not take them time to be able to comply with the Indian law, and they should set the ground running. So yes,
Seems to be
a
a
lot of
prepared.
yes, a lot of those thoughts coming in from the MOS at the first meeting itself. So yes, I mean, a lot of these questions we did raise, but like I said, we know the responses of the minister now, and you all can also go back and check the PIB's official press release on yesterday's consultative session with the MOS, and all of this that I'm saying is also part of the official press release. So a lot of thoughts coming in from the government, and a lot of emphasis on compliance.
Probably the right time we have you here board, because last night it ruled out and the information was in live, and now you have here a lot of insightful
Yes.
guidelines we see. So with this audience, please don't feel bad. We will be answering all these left out questions in the community. Raki, please share it with us. We will make sure that it's all addressed. And over to you, Raki.
Yeah, and thank you all. We can see that the questions are still flowing in.
Flowing
I
in.
don't know if this, I mean, I'm feeling bad as well.
It
Maybe
requires another session, or
this will be another session. I think we've gone in the chronological order, so please don't feel bad. You can take our email IDs from
yes.
Raki. Yes, my email ID, I'll also announce it here. It's mehak.k@khaitanandkhaitan.com. Raki will also put it out, and with probably the recording of this session and elsewhere as well. We'll try picking up as many questions that we can, but we're just running short of time. Over to you, Raki.
Thanks, Mehak. Thanks, Bhuvna. This was such an insightful discussion, and we can see, still questions are flowing in. So thank you so much for all the insights shared. We have definitely, learned a lot today on this DPDPA Act. So thank you so much, Mehak. Thank you, Bhuvna, for the wonderful moderation. Also, thank you to all the attendees who joined and make it more engaging, insightful with all your questions. And as told by both Bhuvna and Mehak, we will be sharing there's a great rep community that we have. A lot of you are already members of the community. So if your question was not answered, or if you have any other questions related to this topic, please feel free to sign up to our community. The URL is available there, and you can sign up today, ask your questions, and our subject matter experts will guide you with the responses which are there. Also, as promised by Mehak, we will also be sharing her email ID with you with the recording of the session. So if you want to personally reach out to Mehak for any questions, you can do that. So thank you so much once again, everybody. It was wonderful to see such engagement. And once again, thank you, Mehak and Bhuvna, for this discussion today.
Absolutely.
Thank you so much. Our pleasure. Thank you so much for Bhuvna for a great discussion. I loved my time here. Thank you so much, Rakhi, for this amazing seminar and for organizing it so seamlessly. And thank you to the entire greytHR team here, and to the wonderful attendees. Yes, more than 150, and for the multiple questions that you had for us, feel free to send your questions, and we'll try answering all of those.
Sure. Thank you so much, Mehak, for your kind
Thank
words.
you. Thank you.
Thank you so much once again, everybody. Until next time. Thank you so much.
Bye.
Bye.